Can I file a trademark application before I actually begin using my trademark? I'm going to spend the next 4 minutes discussing this. I'm Angela Langlotz, trademark and copyright attorney. I go live here on weekdays to answer trademark and copyright law questions. If you have questions, drop them into the comments below. I'll answer them on a future live video. So somebody asked me, hey, can I apply to register a trademark even if I'm not using it right now? And the answer is yes, absolutely. There are two bases under which we can file a trademark application. The first one, and the one that's most commonly thought of, is one based on your actual current use of the mark in commerce. That's called the use basis. There's also a basis called the intent to use filing basis, and people use that frequently. Why? Why would somebody want to apply to register a trademark that they're not using yet? Well, there are a couple of reasons. Reason number one is perhaps because you've been using the trademark, but there's been a little problem with your usage and maybe you can't prove it, or you want to file a trademark application, but you can't really pin down right now when you started using it, and so you don't have a firm date of first use and you want to go back and research it, but you want to get the application filed. That is an instance where you would file a trademark based on your intent to use it. Even though you're kind of already using it, you can still file based on your intent to use and then file the statement of use later when you have your date of first use nailed down. So that's one situation. The second situation, and the most common one, is that you're developing a new product or service and you have a really great name and you don't want to lose it. You don't want somebody else to come in before you've had a chance to use the trademark because you're still developing the product or the service, and you don't want somebody to come in and file an application that maybe would be competing with yours or be identical to yours. The other thing too is when you're out there and you're talking about your brand or your idea, sometimes other people hear about it and they go, aha, that's a really great idea. I wonder if they filed a trademark application. They go in and they look at the record and they discover, oh, nobody has filed a trademark application for this. I think I'm going to file my own intent to use application and I'm going to steal their brand right out from under their nose. It happens pretty frequently. People do crappy stuff like that. So in order to prevent that, the wise trademark applicant will say, you know what, this is a really great name and I know I'm going to use it on my product moving forward. I'm going to get the trademark process started so that while I'm developing my brand, my trademark application is inching forward in the waiting line to be examined by the trademark examiner. Now it's taking about 6 months for a filed application to come up to be examined. So the sooner you get the process started, the sooner you can have it examined and have some certainty about what the trademark examiner is going to say about your application. So those are two really great reasons why someone would file an application based on an intent in the future to use a trademark. I'm Angela Langlotz. Find me online at TrademarkDoctor.net. I'm also on YouTube at video.TrademarkDoctor.net/YouTube. And you can find me on Facebook as well at facebook.com/TrademarkDoctor. Like and subscribe to get all of my newest content.